In the case of public prosecutor versus Hanif Basree bin Abdul Rahman, it was an appeal case where initially the respondent was charged in the High Court Kuala Lumpur with the offence of murder. He was alleged to have murdered Norita binti Samsudin on the 5th December 2003 between 1:30 a.m. to 4 a.m. in an apartment at Sri Hatamars. The body was found by SP12 and SP28, who had earlier noticed a strong unpleasant body odor at the main entrance of the apartment. The deceased body was found face downwards on the mattress on the floor of her bedroom. Her head was covered with a pillowcase and her hands and legs were tied. Her mouth was stuffed with two pieces of face towel. So the trial judge found that although it was ascertained that the deceased has sexual intercourse within 72 hours of her death, the evidence could not ascertain with absolute certainty that the respondent was the last person to have sexual intercourse with her. At the close of the prosecution case, the trial judge found that the prosecution has failed to prove a prima facie case and the respondent was henceforth acquitted and discharged. The prosecution's appeal to the Court of Appeal, however, it was dismissed. Hence, the prosecution's appeal to the Federal Court. However, the Federal Court dismissed the appeal as the judge had correctly examined the evidence adduced before him and had correctly applied the principle when assessing circumstantial evidence, particularly as in this case, when there was a reasonable likelihood of assistance of another person who could have committed the offense instead of the respondent itself. Thus, the learned trial judge was right in deciding not to call for the defense and acquitting the accused at the close of the prosecution's case. So what I feel about the decision is that the decision was made fairly and correctly from the starting point itself at the High Court itself. As we can see, the prosecutions had failed to prove the case beyond reasonable doubts or proof of prima facie case, starting from the High Court until the Federal Court. So I believe that there will be no errors in the interpretations of issue of laws by every court, especially on the issues related to the admissibility of the circumstantial evidence. I'm totally agreed with the decisions of the Federal Court, where the court had decided that there was a reasonable likelihood of assistance of another person who could have committed the offense, which led to too many doubts in the prosecution's case, which have failed to prove a prima facie case against the respondent. So I think that the prosecutions should not just merely rely on the circumstantial evidence itself to prove their case against the respondent, as the evidences adduced by them were not concrete and strong enough, and there were many doubts arising from the facts itself. So, such as the existence of the DNA belonging to the unknown male, one, and the unpleasant odor found by the SP12 and SP28 when they found the body, and also the credibility of the two security guards at the condominium, which they have said that they saw the accused. The accused was together with the deceased and two Malay couples in a kancil a few hours before her death. All in all, I would like to reaffirm my choice that I'm really agree and totally agree with the decisions made by the Federal Court in dismissing the appeal. In this case, the court had held that in considering all the evidence taken together, there was a reasonable likelihood of assistance of another person who have committed the offense, which led to too many doubts in the prosecution case, which I've mentioned above, and this eventually the prosecutions have failed to prove a prima facie case against the respondent. In this circumstance, we may look into the general rule itself in governing the circumstantial evidence. Generally, the circumstantial evidence may refer to any facts from the existence of which the judge may infer the existence of a fact in issue. These facts are not direct to the facts in issue, but it is evidence of various circumstances which are connected to the facts in issue and taken together from a change of circumstances, inviting the court to draw an inference or presumptions of the principle of fact. The test for admissibility of circumstantial evidence in court is that it has to be relevant to the facts in issue itself. And it can be covered in the sense of Sections 5 of the Evidence Act 1950. The test in admitting circumstantial evidence is not the same as to the test in securing a conviction when all the evidence is circumstantial in nature. So, for example, a girl she went to B's house for tuition. After the tuition, she did not return home, and the next day her body was found dead in the abandoned shop lot nearby B's house. Subsequently, B was being charged for raping and murdering A on that night. However, based on the circumstantial evidence adduced to the judge by the prosecutions, which have failed to prove the existence of B sperms in the vagina of A. So, in fact, it was another person's sperm was found. Also, there's doubt here that in the evidence adduced by the prosecutions. So, those, according to the general rule, where A was being raped and murdered by B, the contention itself will not sufficient to prove that the evidence adduced is connected to the facts in issue. So for cases which are based purely on circumstantial evidence, all the circumstantial evidence tender must be capable of leading to one irresistible conclusion, that is guilt of the accused. The test of irresistible conclusion is equivalent to beyond reasonable doubt. We can refer to the case of Idris versus public prosecutor, where the learned judge of this case said that, in other words, circumstantial evidence consists of this, that when you look at all the surrounding circumstances, you find such a series of undesigned, unexpected coincidences that as a reasonable person, you find your judgment is compelled to one conclusion. So if the circumstantial evidence is such as to fall short of that standard, if does not satisfy that the test, if it's leave gaps, then it is of no use at all. As I have stated, in this case depends entirely upon circumstantial evidence. In another case of Datuk Mokhtar bin Hashim versus public prosecutor, where the judge have said that where circumstantial evidence is the basis of the prosecution case, the evidence proof must be irresistibly point to one and only one conclusion: the guilt of the accused. But in a case tried without a jury, the failure by the court to expressly state this is not fatal, and it will be sufficient if it is merely say that it is satisfied as to the guilt of the accused beyond reasonable doubt. In another case of Chun Chuan Kong versus public prosecutor, where the court found that the evidence is wholly circumstantial, what has to be considered is not only the strength of each individual strain of evidence, but also to combine the strength of these strains when twisted together to make a rule. So to sum up my evaluations of the decisions, I would like to re-emphasize on the point that the federal court had held correctly upon the appeal by the prosecutions. As there were many doubts arises from based on the facts itself. Firstly, the existence of the DNA belonging to the unknown male one. Secondly, the unpleasant body odor noticed by SP12 and SP28 when they found the body. And thirdly, on the credibility of the two security guards on the condominium, which they have said that they saw the accused were together with the disease, and two Malay couples in Kanchu a few hours before her death. So all this will lead to the failure for the prosecutions to prove a prima facie case against the respondent. In conclusion, the circumstantial evidence may be a good evidence to be applied in every case when there is a concrete and sufficient evidence in connecting to one another which relevant to the facts in issue. However, we need to be noted that sometimes the circumstantial evidence cannot be wholly relied upon to sustain a charge of an offense, as it may be fatal to the case itself. But if the prosecutor or defense counsel are pretty sure and confident with their evidence in proving circumstantial evidence, then they may do so, as it is a good evidence to support their arguments and in convincing the judge. Upon the future applications of this evidence in court, I would like to suggest that the court need to be strict in deciding the admissibility of the circumstantial evidence. The court should only accept the concrete evidence which can be proven to be relevant to the facts of the case. Before considering the evidence, the court should decide whether the evidence tender is fair and reasonable for the further stage of proving the evidence. Therefore, the court should look deeper into the evidence, whether it can really connect and relevant to the facts. By that, the prosecutor will not only fully rely on this evidence, but will also tender other evidence to support their case. Thank you.